Hello guys, and welcome to another episode of our civil litigation mock trial course by the DECO Daniel School of Law. On today's episode, we are talking about the draft of statement of claim. How to draft statement of claim for the purpose of bar finals. That's bar finals at the Nigerian Law School. How do you properly draft a statement of claim? I can tell you for free, I can tell you that you will always, in every civil litigation exam, draft statement of claim. You will draft it, my dear. Don't even stress yourself. You will draft it. The same way, take it for free again, that you are going to draft interlocutory application. There are just certain things. If you want to pass bar finals at the Nigerian Law School, civil litigation, I'm speaking contextually here. If you want to pass civil litigation bar finals, there are just certain things that are as religious as going to church every Sunday, even though I know most of us don't. But you get my point. So we're expected to go to church every Sunday, right? That's the same way you're expected to know how to draft, your statement of claim, your statement of defense. I've not seen where they asked us to draft a reply, but I know that you must draft your statement of claim and your statement of defense, right? Is it that they tell you to draft statement of defense? Sometimes. But even if they don't tell you to draft the statement of defense, they are likely to tell you to draft some parts. So, for example, the general traverse, right? And things like that. So I am just giving you this prelude, right? That, okay, these are the things that you're supposed to know. Passing civil litigation is not just about reading the entirety of civil litigation textbook. It's knowing where exactly to read, where exactly to focus on for the purpose of bar finals. And I can tell you for a fact that this is a very key area for the purpose of bar finals. And also for our mock trial course, during our trials, you will definitely draft statement of claim, right? Because if you are initiating an action, there has to be something attached. And if your action is initiated by a writ of summons, then you of course have to, attach your statement of claim, right? If you understand what I mean. So for our mock trial course, you would definitely have to draft it. Now, let's go to our drafting class for today, right? Now, it's time for us to start, right? So when we are talking about the draft of statement of claim, I am going to still teach you some past questions, right? Because there are certain key things that you're supposed to look at in a past question. So, for example, you can see on your screen now that you have the heading of the court, right? So in the High Court of Lagos, in the Lagos Judicial Division, holding at Lagos, then suit number. So the question is, how do you know if I'm supposed to bring the action in the High Court of Lagos or I'm supposed to bring the action in the High Court of Abuja? Do you understand? That's the High Court of the Federal Capital Territory, Abuja. How do I know where to bring it from? Now, don't forget that in our course, when I was teaching you jurisdiction, right? And I was also teaching you commencement of action in the High Court, Module 5, right? In the beginning of that Module 5, I taught you that there are certain key things that you're supposed to look at in exam. So, for example, if it's a contract, right? If it's a contract, the substance of what they are discussing about, the issue is a contract. What do we look at? Where the defendant stays or resides, or where the contract is to be performed. Right? So most times you are supposed to use where the defendant lives or carries on business. Do you get my point? So the moment you look at it, but if it is land, what did I tell you that is the indicia for knowing where to bring an action when it's for land? It has to be where the land is situated, not where the defendant resides or carries on business, not where contract is to be performed, where the land situates. So if everything happened, the defendant, everything is in Lagos, but the land is situated in Abuja, then you ought to know that your heading of the court will be in Abuja. Do you get my point? If it's a contract, so all these things I've already detailed it in the course. So I don't want to rehash it now. I'm just bringing it. So we've learned the heading. We all know this heading in the High Court of Lagos and the Lagos Judicial Division holding at Lagos. And we also know how it ought to be if it's for Abuja. So that's done. If you do not have so much knowledge on this, then I would advise that you go back to watch the entirety of our Module 2 where I taught jurisdiction, and also our module 5, where I taught commencement of actions in the High Court. Do you understand that? So if you have watched these things, I think they're in total about 30 to 40 videos. If you have watched this, then I'm very sure you'll be fine in that regard. Now, the next thing now is suit number. It must be in your statement of claim. So after you have talked about the heading, you know how to get your heading, and you know how to couch your heading. It's either Lagos or Abuja that you'll be told to draft in all the civil litigation exam I've seen. So note that if it is Abuja, in the High Court of the Federal Capital Territory, Abuja, then in the Abuja Judicial Division, holding at Abuja, the holding is EN, not ING. It has come out in an exam before where they said that you should redraft the statement of claim and they put ING, right? So the holding is EN. Do you understand that? And if it's Lagos, you know how to draft that of Lagos. Then suit number, do not forget. Do you understand? Then you now go between parties. Now, in this case now, I used representative action because I wanted you to see how representative action is drafted. Do you understand that? And I also used company because if it were a normal human being, that one is easily. Do you understand? But what if it's a representative action? How do you draft a statement of claim when one of the parties, is brought in a representative capacity? What about when one of the parties, is a company? How do you draft it? And that's why I am bringing these two things here for us to see. Do you understand that? So we go to the parties clause. I have taught you in parties to a civil suit, our module 3. Our module 1 was where I talked about the overview of civil litigation. And then I gave you about 10 classes. Our module 2 on jurisdiction, there were about 20 classes only on jurisdiction. Our module 3, we had about 20 classes as well. So under our module 3, I taught you that when you are bringing an action in court, you have to look at the parties that are bringing the action. And I told you when you sue in a representative capacity, where there are so many people, but they have just one interest, then what do? You bring all of them and then you put them, in one party. But then you are going to bring about 1 or 2 or 3 or more people that will now serve as a representative of that this thing. It can be a family, it can be an estate, it can be whatever it is. But where 2 or 3 or more people are having an issue, and that issue cut across all of them, then what do? You bring a representative this thing. I don't want to teach again and again and again. Do you understand? So if you have not watched my class on representative action, please go and watch it. So how do you sue when it's a representative action? You bring number 1, the person that is suing on behalf of. Number 2, the person that is suing on behalf of. If there are more than 2, then you write them out. But if there are just 2, then you put them the same way you can see it right now. Then this is the key thing that law school wants to see. Suing for themselves and on behalf of so. And in this case, they are suing on behalf of the Ogbonge family or Siromawa Ikeja Lagos. Do you understand? So they are suing on behalf of the Ogbonge family. So whatever it is, you need to put suing for themselves. You can't just say suing on behalf of. Because if they are suing on behalf of, it is no longer representative. Because representative means that they have to be one of them first. And so they are suing because of their own interest, and they are suing on behalf of the interest of other people. So suing for themselves and on behalf of the so. So, for example, now you are currently at law school, right? And then there are some law school students that were unjustly rusticated. Let us say about 30 of you were unjustly rusticated from school. Now, the implication of that is that there are going to be 30 different suits suing law school. Do you see that? So instead of you to have 30 different suits suing law school, why don't you sue for yourself and on behalf of the others? Therefore, you are representing them. Why it is called a representative action. Do you get the point? So we use representative actions because we want to reduce the amount of suits, especially when the interests are the same and they cut across different persons. So we use the representative action. And don't forget that I've taught you the difference between representative action and class actions. I already taught it in the course. So please go back to our module 3 where I taught parties to an action to be abreast of that. And then we have the Agritex Agro Allied Limited. This is a company and that is the defendant. Do you understand? So you can see the way these things are. We have the heading of the court first, then we have the suit number, then we have the parties. You need to know how to properly couch your parties to be able to pass your bar finals. These are the points where law school wants to see and they are going to mark. So please watch Parties to a Civil Suit to learn how to draft properly. Now the next thing is you have to boldly write statement of claim in capital letter. Boldly write. If it is a statement of defense, then you write statement of defense in capital letter. We are still going to have our class where I will teach you how to draft statement of defense. But you must write it boldly and in capital letter. If it's a reply, do not forget that when I was teaching you pleadings, I taught you that there are 3 types. We have the statement of claim, we have the statement of defense, and then we have the reply. And also do not forget that when I was teaching you, I taught you the time frame for which they are to be filed. A statement of claim is supposed to be filed at the point where you are filing your originating process. And I taught you the implication of not doing so. If you are in Abuja, it is treated as a mere irregularity. But if you are in Lagos, then it is not a mere irregularity. It is a nullity, the entire trial. When are you supposed to file your statement of defense? In Abuja, 21 days. In Lagos, 42 days. If you are in Lagos, you are supposed to file your reply even when accompanied with a defense to the counterclaim in 14 days. Right? While if you are in Abuja, you are supposed to file your reply in 7 days, but when it is accompanied, that is, the statement of defense is accompanied with a counterclaim, then you are supposed to file your reply and defense to the counterclaim in 14 days. Right? These are things that you are supposed to know, which we have already taught in our classes on pleadings. But here right now, we are talking about the statement of claim, which is the first pleading that is filed. Right? And now we've talked about the preliminaries before we now enter the statement of claim itself. But now that we are in the statement of claim, there are other certain key things that we need to pay attention to. So I need you to know that the pleading should be drafted in paragraphs, numbered consecutively, with each paragraph containing a specific allegation. It's important. The pleading must be what? Must be in paragraph, and it must be numbered consecutively, each paragraph containing a specific information. So which means that when you are drafting your pleading, make sure that you don't give us more than one information per pleading. I think I talked about this when I was teaching our pleadings class. That I was telling you that so that when the defendant wants to respond to that particular paragraph, there will not be so much information in the paragraph to the extent that the defendant would not know which one to respond to. So let it just be one paragraph. Right? One paragraph, one information, one specific information that you want us to know. Please take note of that when you are drafting. We are still going to look at this. Now, also, you should know that the fact should be stated in the order in which they occurred to make for coherence. The case of a party comes across more clearly if the facts are arranged in a chronological order and trial flows easily in terms of evidence and tendering of documents. I've told you, I think I said this again when I was teaching my pleadings class. I said it that when you are drafting your statement of claim, you should draft like you are telling a story. I can remember saying that, when we were younger, we used to watch video of one very old Baba that would gather children, and then we would start telling them stories. And then he would say that once upon a time, they lived a boy who came from a very poor family, and they used to struggle to eat. Then they would go to the stream to fetch water, and they would, do you get? You can see that there is a chronological flow. Right? So the boy now went to school, then he got a scholarship, then he got married, then he kinikon, and all that. There is a chronological flow from when the boy was very young, how things happened, right? When he was young, till he now became old and started having his own children. There is a chronological flow. We are not doing flashback and all that you first start from the end, you will now go to the middle. We don't do that when we are drafting statement of claim. So when you are drafting a statement of claim, start from the very beginning of things, right? If there is an issue that had started since 1952 during your forefathers' era, and that issue is upon which you are instituting an action today, you must start it. That is your statement of claim. You must start drafting it from that 1952 when the issue started. Why? Because you are supposed to give us a coherent flow of facts. Do you understand? You are supposed to give us a coherent flow from the beginning, step by step to where we are today. Do you understand that? So what are the things that I've said so far that will guide you when you are drafting? Number one, it should be in paragraphs, right? Numbered consecutively, and each paragraph having a specific allegation. Number two, that the fact should be stated in a coherent flow, in a chronological order, so that the courts and also parties would not misunderstand certain things, right? Having said that, another thing that we need to take note of, which is our number 3 here, is the fact that the first 2 to 3 paragraphs should contain what is known as matters of inducement. First 2 to 3 paragraphs, and I think I've taught this in my course, especially when I told you that when we are talking about matters of inducement, they are only things that introduce the parties. And in our case here, this is our matter of inducement. So the first one is the claimants are members of the Ogbonge family of Chiroma Ikeja local government of Lagos, who are suing for themselves and on behalf of the Ogbonge family, and they reside at number so and so within the jurisdiction of this honorable court. Number 2. Now, the first one is where you introduce. That is number 1. You introduce the claimant. That's what they call matter of inducement. You let us know who is the claimant and where does the claimant live. If you were a person now, you are going to say something like, the claimant is a lawyer. That is, if dear Court Daniels is the claimant. The claimant is a lawyer who resides at number so and so within the jurisdiction of this honorable court. Do you understand? If it were a person. So because I know that person is easy, that's why I did not put it here, right? Even though that I've just used person. So person is, the claimant is a lawyer. The claimant is a businessman. The claimant is a medical doctor. After that, what next do you tell us? Where he lives, who resides at number so and so. Then lastly, what do you tell us? Within the jurisdiction of this honorable court. But when it is, suing in a representative capacity, then you say the claimants are members of the Ogbonge family of Chiroma so and so local government, who are suing for themselves and on behalf of the Ogbonge family, and who now reside at number so and so, the address within the jurisdiction of this court. Do you understand? So you can see how we are taking it step by step. We first started from the heading of the court. How do you determine it? We then went to suit number. Then the parties. How do you properly draft your parties? Then the heading, statement of claim boldly written. Then the first paragraph should be matter of inducement, introducing the claimant. The second paragraph, if there are no more than one claimant, then the second paragraph should be matters of inducement, introducing the defendant. In this case, the defendant is a limited liability company engaged in the business of farming and export of agro-allied products, whose registered address is at number 16 Smart Street, Chiroma Ikeja, local government of Lagos State, and within the jurisdiction of this honorable court. So I want you to see another thing here. When we are talking about the company, you say that it's a limited liability company. You tell us it's a limited liability company. What do? They are doing so and so. You can go as far as saying with registered number. Do you understand my point? right? So it's just like when you are drafting a deed of assignment. You know when you are drafting your parties clause, right, in a deed of assignment, after your commencement, and then you are going to your party, your commencement, your dates, then your parties. You are saying that, ABC Limited, a limited liability company registered under the Companies and Other Matters Act 2020 with RC number so and so, and having the registered office at number so and so, the assignor on the one part. Do you see the way that is? Right? You see the way you draft it in your deed of assignment. Now, when you are drafting in your statement of claim, there are just certain things that you need not put. But you have to tell us that it's a limited liability company. Right? You have to tell us what they do. Now, you are telling us what they do in your statement of claim. You are not telling us what they do in your deed of assignment. Do you understand that? You are not telling us what they do in your deed of assignment under the parties clause. Right? So I'm trying to juxtapose those two things for you for the sake of better understanding. So if it's a statement of claim, you just tell us that it's a limited liability company, you tell us what they do, then you tell us where they are, but please do not forget to add within the jurisdiction of this court, if they are indeed within the jurisdiction of the court. Do you understand what I mean? So you can see the way we drafted the matters of inducements. Now, note that if you have more than one claimant, then your first paragraph is going to be the first claimant is so and so. Your second paragraph, the second claimant is so and so. Your third paragraph, the third claimant is... Do you understand? But if you have more than one defendant too, then your fourth, we have three claimants now. Your fourth paragraph will now be the first defendant is, your fifth paragraph will now be the second defendant is, your sixth paragraph, the third defendant is. Do you understand that? Right? That is how you start drafting your statement of claim. Now, let's take it a step further. You can see that in our paragraph, matters of inducement, what is the specific thing that we are trying to do there? We are trying to introduce the defendant. Now, we now go to the next thing. The claimant avers, which is the language that you use in drafting. The claimant avers. Each time you want to say something, the claimant avers. The claimant does not say. The claimant says that, The claimant talks, say, The claimant what? The claimant avers. And that is why when you are referring to each of these paragraphs, the language to use is averments. The claimant averred in his third paragraph, my lord, that... Do you understand? They are called averments. So the claimant avers that the Ogbonge family inherited the land lying and situate at number 17 Smart Street, Sirumawa, whatever this thing is, local government in Lagos, from their ancestors within the jurisdiction of this honorable court. Now, the land itself, which is what I'm telling you about, they have established one very key thing that gave the court jurisdiction. They told us where the land is, and the land is situated within the jurisdiction of the court. But that paragraph serves two purposes. Not only did the paragraph tell us that, this land, which is the subject matter of dispute, is within the jurisdiction of this court. The paragraph went further to start the whole issue. Look at the way the paragraph is couched. It says that the claimant avers that the Ogbonge family inherited the land from their ancestors. My lord, that is the first point of call. Because do not forget that your draft must be in a what manner? In a chronological manner. Do you get my point? Therefore, you must tell us from the very first standpoint, what is going on and how we proceeded from there. Now, look at the second one. The ancestors of the claimant first settled on the land from time immemorial, and the land has since devolved to members of the family. Now, if you don't know how to use this I, please don't use it. Now, when do you use this I? You use it when you want to say certain things, right, from the main thing that you have said. Look at number 4 now. In number 4, you said that the ancestors of the claimant first settled on the land from time immemorial, and the land has since devolved to the members of the family, right? You can then add in front as follows, if you want to. Or even if you did not, like I did not here, you just add I, I. Why? Because you want to tell us how the devolution went. So that paragraph is only for the devolution. One specific thing that we are learning there is that this land, from time immemorial, belong to our family, and then from one generation to another generation to another generation, it now came to us. Right? But you don't want to keep putting in number 5 one generation, number 6 another generation, number 7 another generation, and you cannot mumbo jumbo it too much in a paragraph. That is why you now decided to put it as a sub I. So we have a sub paragraph. Do you understand? A paragraph which is 4, then a sub paragraph in that 4. So in this case we now have 4I. The land was founded by Oba Ogbonge, who gave birth to Fuji and Fela. Then I. So Fuji Ogbonge gave birth to Adewumi and Dong. I. Dong gave birth to Ogbonge and Kiki. Now, Ogbonge, who was born in 1939, on whom the land has devolved, and the father of the 2 claimants, is the patriarch of the Ogbonge family. So there is something I want you to see here. Look at the devolution. So they have told us that, okay, in paragraph 3, they told us that, my lord CEO, this land falls within the jurisdiction of this court because it's situated in this area. But apart from that, this land, it came from our ancestors. This, before we even start anything, let us have that in our head now. This land, it came from our ancestors. Then number 2, you now went further. Okay, from our ancestors, time immemorial, which means that we cannot peg the particular time where our ancestors had this land. However, we can show you our ancestors and show you how the land passed across to the current patriarch of our family. Do you understand? So number 4 now says, the ancestors of the claimant first settled on the land from time immemorial, and the land has been devolved to the members of the family. Like I said, there is a silent as follows in front there. If you don't want to write it, it's fine. You then go and then start listing. The land was founded by Oba Ogbonge, that is the first settler, the original settler on that land. Do you understand? You know that there is this, I don't want to teach land law right now because I want to venture into a little bit of land law. There is this saying, I read the Obasanjo's book, My Watch, where he was talking about the origin of the Yoruba people and said that the myth that he aligns with is the one that says that the Yoruba people came from Mecca. And then when something happened on Balam Rudu and all that, we left Mecca, Oduduwa left Mecca and started working down from Mecca to Oshun, Ile-Ife. Now, when he was walking, of course, there were certain people that were aged or were pregnant and could not go as far as the distance as Oduduwa could, right? And then he started dropping them bit by bit on the road. And that's one of the reasons that the Yoruba language is not, you have the normal Yoruba that everybody can speak. Then you have the Ijesha Yoruba, you get my point, right? They are different, the Ibadan Yoruba and all that. They are different Yorubas, and this is one reason why we had that kind of difference in the Yoruba language. Now, what is my point here? Now, when he was walking, right, he kept on dropping people on empty lands. Those people are regarded as the first settlers on those lands. Do you understand? So in this statement of claim, the first settler that we are referring to here is that the land was founded by Oba Ogbonge, right? So he is the first settler on the land. And that our Oba Ogbonge, that is first settler on that land, gave birth to Fuji and Fela. One paragraph. Then he went down. Fuji Ogbonge, the son of Oba Ogbonge, gave birth to Adewumi and Dong. Now, Dong from Fuji Ogbonge gave birth to another Ogbonge, of course, Junior, and Kiki. Now, that Ogbonge now was born in 1939. So we couldn't tell you how our ancestors, the time frame of the ancestors, but the one where we can start from is the one of Ogbonge, but we can trace the history. We can trace the history in terms of the persons that gave birth to who, right? But we cannot just hold our hand as to the particular date of settling on the land and things like that. So Ogbonge was given birth to in 1939, on whom the land has devolved, and the father of the two claimants is the patriarch of the Ogbonge family. So you can see, I just want you to see how, which is the essence of this, so that when you are drafting in exam, it gives you that idea on how you are expected to draft. Do you understand what I mean? I want you to see how we flow in this drafting. Do you understand? So from the matter of inducement, we now go to our first point of action. What is our first point of action here? The first thing that started. Then after that, we begin to give certain explanation. Now, let's go a step further. Now, the claimant avers, I told you that what you say is that what? The claimant avers. The claimant avers that on the 5th of April 2016, the defendant entered and began clearing of the land belonging to the claimant family at number so and so. We already know the address. Okay, so you can see the claimant first established ownership. They showed us through paragraph 3 and paragraph 4 that they are the owners. Then in paragraph 5, you can see that there's just one information that is given in our paragraph 5. Right? And that was that one information, that the defendant entered the land of the claimant and started clearing the bush, which of course is going to be trespass. Right? Then we'll now go to our paragraph 6. The claimant avers that the defendant claimed that the land was allocated to it by the Lagos State government by a certificate of occupancy dated 12/7/2019. Now, don't forget that I told you that when you are drafting, especially in pleadings, you do not attach documents. You know that if this were an affidavit that we are drafting now, what would I have said you should do? The certificate of occupancy dated the 12th of 7/2019 is hereby attached and marked exhibit so and so. Right? If this were an affidavit, you will say it's hereby attached or herein attached and marked exhibits. Abi? That's how I taught you affidavit. But in pleadings, in practice, please note, in practice, and I taught this in our pleadings course, in practice, when you want to plead a document, not only are you supposed to plead it the way you have pleaded it here, you are now supposed to say that the certificate of occupancy is hereby pleaded and shall be relied on at trial. That is in practice, ladies and gentlemen. You don't say it's hereby pleaded and shall be relied on at trial if you want to pass law school exam. But in practice, I taught you when I was teaching my pleadings course that when I was in my law firm, and then all of a sudden I was drafting a statement of claim, I didn't put all those is hereby pleaded. I submitted it to my senior, who has been in practice, a senior associate, who has been in practice for more than 12 years now. And then he said, Diako, you didn't plead any of the documents that I sent to you. I said, I didn't plead. Bao. So didn't you see where I spoke about the document? He told me that in practice, you don't just speak about the document. You must specifically say that this document is hereby pleaded and shall be relied on at trial. And you put it in bold. And I'm like, no, they didn't teach us that one in law school. He said that information that you have from law school, drop it at the gate of law school. Now that you're in practice, you begin to put new information in your head. So I am telling you this so that when you see this document is hereby pleaded and shall be relied on at trial, as in this case now, this certificate of occupancy dated so and so, we ought to say that it is hereby pleaded and shall be relied on at trial. Now, when you see it in pleadings, don't think that you have not been taught properly. Just understand that for the sake of law school, you shouldn't add it. However, if you do not believe what I'm saying, you can go and meet your lecturers in law school and ask them, sir, when we are pleading a document, should we say that so and so is hereby pleaded and shall be relied on at trial? If your lecturer said I should add it, then maybe as at the time you are listening to this lecture, it is such that the law school terms has changed. Right? But I know that during my own time, especially when I asked my own lecturer, he said that it is not necessary. Now, to continue, the land, that's paragraph 7, the land has not been acquired by the Lagos State government. The family, paragraph 8, has never been paid compensation on the land. Then we now go to our claim, our reliefs. Do not forget that when I was teaching you statement of claim, I told you that there are certain parts right? In a statement of claim, we have the part for the relief, as we are about to go to now. We have the part for the matter of inducement, which is the first and second paragraph. Then we have the body. The body of the statement of claim is where you do your whole shalaye, your explanation. How is an ancestral land? How the defendant entered your land? How the defendant said that the property was given to him by the Lagos State government through a certificate of occupancy. How all those things are to be in your body. So immediately you write your what? Your statement of claim. That's the heading. You know, after your normal heading of the court, suit number and parties, then your heading. Immediately you write that heading. The next thing is your matters of inducement, first and second paragraph, if there are only one defendant and claimant. Then the next thing is your body. When you are drafting your body, please note that just one information per paragraph. Please note that it should be done chronologically. The fact should be done chronologically. Please note that you do not attach document. You should plead it. By pleading it, you are making reference to the document. The same way in our paragraph 6 here, the claimant made reference to the document when he said that the claimant avowed that the defendant claimed that the land was allocated to it by the Lagos State government by a certificate of occupancy dated. Now, the fact that he said that there is a certificate of occupancy dated, he referenced the existence of a document. That reference alone amounts to pleading, right? But for the sake of law school, it amounts to pleading. Before we get to the reliefs and I explain further on the reliefs, I think there are certain points that I still need us to look on. Do you understand? One of those points is that, please, the use of pronouns should be avoided as far as possible. This is to avoid ambiguity and to encourage clarity, right? There must also be consistency in the use of terms. Do not use claimant in one paragraph, then use the name of the person in another paragraph. Don't use pronouns. I'm begging you. Don't use he, she. Use claimant, the defendant. The defendant avows that the claimant avows that the defendant. If you are referring to a company, always replicate the company each time you want to mention it. So the claimant avows that First Bank Nigeria Limited did not give him money. The claimant avows that First Bank so and so. Do you understand? Don't say that the bank. Say First Bank. Keep saying First Bank so that there will be consistency in the person that is reading your statement of claim. Once you have used First Bank first, right? Keep saying First Bank as you keep going, right? Be consistent in what you use to name a person. Mr. Taiwo is Mr. Taiwo. So in your statement, don't say that, let's say in the first paragraph, you already referenced Mr. Taiwo. Then you now go to your second or third paragraph. You are referencing Mr. Taiwo, then you are now saying he. He then gave. Who is he then gave? Mr. Taiwo then gave. Do you understand? So that there can be consistency. Please take note of that. Do not use pronouns, or at least reduce it to the barest minimum, right? Except it is very necessary. And also be consistent with the terms that you use. Secondly, when you are writing figures, write figures in numbers, then you open bracket and write it in words. Do you understand? So he gave him the sum of 20 million naira. You put 20 million naira in numbers first, then you open bracket and put the 20 million naira in words. Do you understand that? So these are some key rules I think that we should pay attention to. Then we then go to the reliefs. And then I told you that when I'm drafting my reliefs, I said it in class, that I usually say that whereof the claimant claims from the defendant as follows. That is how I draft my own relief. However, you can say that the claimant claims from defendant as follows, or however you put it, but this is the standard way I like to put mine. Right? Then you then name what your reliefs are. A declaration that the land situated at number so and so belongs to the claimant family. A declaration that the action of the defendant moving its equipment amounts to trespass. You can see that I skipped some things. An order of perpetual injunction restrain the defendant from further act. The sum of 10 million naira as general damages and cost of the action. Note that if you are going to ask for special damages, then you must plead special damages specifically, which means that if you are saying that you are asking for this cost of 50 million naira for special damages, then you must now go so and so was the cost of this. So and so. Let us say that he did not just trespass on the land, which is what you are asking for, general damage of 10 million. He also went further to destroy some of the properties, your borehole machine. He killed some livestock on the land. He bulldozed your gates. So you say that the gates, the cost of rebuilding the gates, which is your special damages, will cost you 2 million naira. He killed 38 chickens, right? 38 chickens will cost, do you understand? So you must specifically plead when you are talking about special damage. But because there's no special damage here, there is no specific pleading. But we have general damage, which according to the rule of pleading need not be specifically pleaded. Do you understand? Then you have your date, which is very, very important. Then the signature of the lawyer that drafted it, the law firm of the lawyer, claimant's counsel, then the address. Then for service on, please do not forget that, the defendant, then the address of the defendant and all that. Because this is part of the originating process, it should be served on the defendant personally. Do not forget our rule. When I was teaching you module 9, I told you that originating process and accompanying documents must be served personally, right? If it is not served personally, it is improper service. The rules of courts in our module 10 being on service of court processes, says that if you are going to serve an originating process and its accompanying document, the statement of claim being an accompanying document to the writ of summons being an originating process, right? If you are going to serve it, it must be served personally. Now, if in the event you did not see that person to serve the person personally and you have tried your best, then you can bring a motion ex parte to serve by substituted means. But at the point of drafting, for the sake of exam, you don't draft to serve on the lawyer, you draft to serve. This is another key exam point, right? You draft to serve on the defendant personally. And personal service would be on the company because it is a company here. Do you understand? So this has been a very beautiful class teaching the entirety of our statement of claim. In our next class, we'll talk about our statement of defense and some of the key things that we are supposed to avert our mind to. I hope you have enjoyed this class. I enjoyed it. I will see you in our next class. Ladies and gentlemen, learning colleagues, please have a very wonderful day.